as particularly authoritative? And the answer is that a faithful interpreter requires necessarily trying to understand the content of that message. Now, the details of what the method might be of trying to correctly identify what it is that the content of the message that's being conveyed through law might be is, of course, up for grabs. And I think there are disagreements within the originalist camp as well as across originalist and non-originalist about that. But I think the place that gets us at least to an originalist argument from a relatively common starting point is this claim that what judges are trying to do fundamentally is trying to interpret and understand and apply and elaborate a message that was communicated, a set of rules that were communicated in an authoritative text. I think, though, that takes us to the external argument, which in general I find to be more interesting. And that is, the external argument is, why do we care about the content of this particular communication? Why should we take that to be the law that needs to be interpreted and applied by judges particularly? One way of doing that is to, again, recur back to the kind of arguments that Marshall wants to make, and even the text of the Constitution itself suggests that it is this Constitution that is the supreme law of the land. But the question really is, why are there particular messages that are being conveyed through the text of the Constitution, whether we take that as being the text of the Constitution, so actual real live text per se, or things that we're trying to tease out of that text, perhaps through original methods, perhaps through other methods. Why should we take any of that as being particularly authoritative, such that it could trump legislative decisions in the here and now? And I think that the key move that has to be made is that it depends on an authoritative lawgiver, right? That we regard those who drafted the constitutional text that we're now trying to interpret and apply as being particularly well positioned, that they alone had authority to make a fundamental law and a law, and it's going to trump subsequent lawgivers that operate with less general authority. So the founders, and read broadly what the founders are in this context, and of course you can try to tease out what exactly we mean by founders, who exactly were those lawgivers that had that kind of authority. But here I'll just say broadly founders, that they were authorized to make law that's superior to law being made by legislatures, and the task of the judge then is to correctly identify what that superior law is and enforce it against those legislatures. So why should we take that seriously, right? So why are those prior lawgivers, the founders, particularly authoritative in this kind of way? And I think that has to rest on an appeal to certain kinds of democratic credentials that the founders had.